Hello and welcome to Legal Links, a legal information program brought to you by the Oregon State Bar. My name is Paul Nickel. I'm the editor of the Oregon State Bar Bulletin and your host for today's program. Today we will be discussing landlord and tenant issues. Previously on Legal Links, we have produced programs on dealing with eviction and renting a home. If you missed these programs, you may view them online at the Oregon State Bar's website, www.oregonstatebar.org. Today's program is meant to be a supplement to the information found on those programs. And with us today to discuss the topic is Craig Colby and Amy Barnhouse. Amy is a partner in the firm Hummel and Barnhouse in Portland, and she has practiced landlord-tenant law for over 10 years. Craig is a partner with the firm of Wall and Colby in Portland. He has been an attorney for over 35 years and practiced in the area of landlord-tenant law for about the last 15 years. Both Amy and Craig are frequent speakers and have been published on this subject. Amy's practice focuses primarily on the representation of landlords, while Craig focuses primarily on the representation of tenants. Welcome to you both.
Hi.
As I mentioned, we've done previous programs on landlord-tenant law, but just to give an overview, could you give us a quick recap on the main considerations when renting a residence?
Well, from the landlord perspective, I would say first off, make sure that you screen all of your applicants, making sure that you get their Social Security number, their work history, their landlord history, to screen out tenants who don't meet your criteria. Secondly, when entering into the rental agreement with your tenant, making sure you're using forms that are tailored from Oregon. There are landlord groups that have forms that are particular for Oregon, such as Rental Housing Association, Metro Multifamily. Stevens Nest also has forms that are tailored for Oregon. It's important not to buy them off the internet or from office supply stores unless you know that they're tailored for Oregon. And then the last bit of advice that I would give to landlords is to make sure you know what the landlord-tenant laws are. I see too many landlords who are not educated when it comes to landlord-tenant law, and they get into a situation where they have a tenant and there's a problem, and the tenant knows more about the landlord-tenant laws than the landlord actually does.
Interesting. What about the tenant side?
Three things. First, and probably the most important, if it smells musty, it is moldy, leave immediately. Don't even consider it. Second, as for the paperwork, you're probably not going to be able to negotiate what lease forms or what the terms are in the lease, especially if it's one of these big management companies. But watch out, because sometimes the rental person tells you you're signing a month-to-month or a year arrangement when in fact they're filling it out the other way, or tells you you're paying a last month's rent deposit when in fact they're assessing a non-refundable fee. So at least read the blanks that are filled in. And third, there'll be a time when you do a walkthrough as you're taking possession of the apartment or the house. The landlord will be in a hurry. Come on, come on, come on. We don't have to know every little thing. Yeah, you do. Because when you move out, the landlord won't even walk through with you. They'll make sure they have all the time in the world and you're not there hurrying them, and they'll note every little thing and use them as an excuse to sue you or to keep your security deposit.
So do your homework at the beginning and not at the end.
Yeah.
Very good. Let's talk about rental agreements. What if a rental agreement is never signed, but you are occupying the residence? Do the same rules apply? What's the law in that area?
Well, you can have a verbal rental agreement with between a landlord and tenant, so there's no requirement that the rental agreement be in writing if it's regular residential dwelling, such as a house or an apartment. Mobile home park rules are different and do require a written rental agreement, but with respect to regular residential arrangement, as long as you have an agreement with your tenant for the payment of rent, and you can have a lease that's less than a year, be a verbal fixed-term lease, and then a month-to-month tenancy would not be required to be in a written format. The downside of that would be that you are limiting yourself to what the Landlord-Tenant Act allows or requires in certain circumstances, and not be able to come up with some of your own terms that aren't covered by the Landlord-Tenant Act, such as requiring that the tenant not smoke inside the dwelling unit. If you don't have something in writing with the tenant, you might have a hard time proving that that was a term of your verbal rental agreement. Because once you get into court, one side will say, yes, this was a term of the verbal agreement, and the other side will deny it.
How do you feel about verbal?
I think the parties can agree orally to be bound by an unsigned writing, at least if it's for a term of less than a year. Otherwise, I think Amy pretty well got it.
Okay. What about background checks and the fees? Is that a common occurrence, and is there a way you can turn that around and do a background check on a landlord?
I suppose you could do a background check on a landlord. I don't know that I've ever heard of anyone who's actually done it. I don't know if Craig's had any clients who've done that. With the computer age and the internet that we have, I think people could do certain types of searches on anyone, including their landlord. There are websites that you could pay to find out public records information, and then you could also do, I suppose, a Google search or go down to the courthouse and find out information on the court records with respect to information on the tenants. The landlords really should be getting an application that's completely filled out by the tenants so that they can do a background check and find out who they're renting to. Now, certainly getting an application and screening someone doesn't mean that they've told you the truth or that they're not falsely using someone else's Social Security number.
Craig, what about the fee? Is that common?
Oh, the fees are common. I've had a number of people tell me that they wished that there was some way they could check on landlords, and I've even thought about how to do it, and have never been able to come up with a good way. I can establish that some landlord files a lot of evictions, but that may only mean that the landlord owns a lot of property or owns a lot of low-income property that tends to generate more eviction cases. What does it prove? Nothing. I could probably find that the landlord's been involved in a number of civil actions. I suppose if I saw a pattern of suing tenants in small claims or getting sued by tenants, I'd say that that landlord is prone to keep security deposits, and that would be a warning. But beyond that, I really don't know what to do.
At the application time, you mentioned having to provide a Social Security number. Is that allowed?
Yes, it would be allowed under the screening criteria. I think that the landlord is certainly not allowed to disclose Social Security numbers to anyone. But when you get an application, the tenant is signing the application saying that they're giving permission for the landlord to do credit report and criminal background and other types of searches, although the public record searches the landlord could do without a signature from the tenant, but the credit report you can't do without the tenant's permission, and the Social Security number is a requirement so that we know we're not getting results from someone else that isn't the tenant who's applying.
And Craig, what advice do you have to tenants when they're at that point in the process?
I don't think I actually have any filled the application out truthfully is all I would say. Landlords are going to be wanting Social Security numbers for an extra reason now, and that is if they eventually need to evict and come down to court to take a default judgment evicting the tenant, they're going to need to be more careful than they have been in the past about proving that the tenant is not in active military service. The easiest way of establishing that is getting a printout from a government-operated website, but that website requires a Social Security number to get any information out of it.
It's actually, just to put in some additional information, it's a Department of Defense website, and you can get information just using someone's name, but because there are a number of people who may have the same name, you might not get accurate results. You might put in Kevin Johnson as a name and find out, well, there's 12 active members of the military named Kevin Johnson. We don't have any way of knowing whether or not it's the tenant that our landlord has. So having the Social Security number helps us better ensure that we're finding out accurate information and representing to the court that the tenant that we're evicting and trying to obtain a default judgment against is not an active military member.
Let's talk about the issue of back rent. If I owe back rent to a prior landlord and then I move, is that debt ever forgiven?
The landlord has a one-year statute of limitations to go after debts that the tenant owes. So if the landlord does not do what they need to do to preserve their claim by filing a small claims action or a regular circuit court action, after a year has passed from the time the debt was incurred, the landlord legally is not entitled to collect that money. What we see typically happening is if there's a security deposit, once the tenant moves out, the landlord will deduct unpaid rent or other amounts owed to the landlord from the security deposit, send the accounting to the tenant, and if there's a balance owed to the landlord, include that balance on there. If the tenant doesn't pay within a reasonable amount of time, the landlord will file a small claims action or a regular circuit court action.
That's, of course, 1 year during which a residential landlord can successfully sue and perhaps collect from the tenant. But I think it's 7 years that debt, if reported to a credit reporting service, remains on the record that credit reporting services are allowed to pass on information about. And it could be a nuisance.
Very good. You mentioned the matter of a landlord recovering costs for repairs needed as a result of tenant neglect or damage. What are the parameters of that? To what extent can a landlord do that?
With respect to deductions from a security deposit, the landlord standard for damages to the premises caused during the tenant's tenancy is it's damages above and beyond normal wear and tear, which there isn't a black and white definition of normal wear and tear. But what I try to tell clients is, depending on how long someone's lived in a unit, you're going to expect some kind of wear and tear. If you've got a long-term tenant who's been in a unit for 5 years, you're going to expect that you're going to need to completely repaint the unit. Charging the tenant for repainting the unit after they've lived there for 5 years would not be something I would advise, and would most likely result in a tenant complaining or perhaps someone like Craig Colby sending off a letter to the landlords indicating that you withheld $500 for repainting the unit. My client lived there for 5 years. This is not an appropriate deduction from the security deposit, and make a demand for reimbursement of those amounts that were withheld from the security deposit. Certainly there are things that would be clear that it would be deductible. The tenant rips the front door off the hinges. That's not ordinary wear and tear. You've got a basketball-sized hole in the wall. Would not be ordinary wear and tear. The mistake I see most frequently is the failure to depreciate certain items, such as paint, flooring, that type of thing, where you might have a unit someone lived in for a year and the place was repainted right before they moved in. They move out a year later and the walls and the paint are in very bad state. The whole unit needs to be completely repainted, and it's not the landlord's practice to repaint after every tenant moves out. You might be able to deduct the cost for repainting less the depreciation, which is the life of the paint that would be used over the year, which usually requires some sort of investigation on the part of the landlord to determine what the life of the paint or the carpeting is going to be in a rental unit. If you've got carpeting that's got a 10-year life and the tenant after 1 year has completely ruined the carpeting and it has to be replaced and there's no other alternative, you would have to depreciate out 10% of the carpet and bill for 90% of the cost of replacing the carpeting.
Is this a common complaint about the fee at the end of the rental agreement, a dispute about the...
I think most tenants think they leave the units in great condition, and I think landlords have many cases will say that the unit was not left in good condition and that there will be some deductions.
Okay.
Most of my clients tell me they've left the place in better condition than it was when they moved in. The thing to remember about the disputes over the condition of the premises are that loser pays the winner's attorney fees if both sides have lawyers and it's in regular court. So when a tenant comes to me unhappy that of the $800 security deposit, the tenant only got back $37, I want to know, how much are you willing to risk to get the missing $760, whatever it is, $63? The attorney fees on that could be, say, if you're dealing with somebody who's reasonable, say $2,000 if the tenant were to lose, and you get these lunatic law firms that'll run up a bill of $10,000 or $13,000 defending on behalf of landlords. The tenant needs to take that into account in deciding to pursue a few hundred, and is usually better off going to small claims for it. And I usually handle those not by writing letters or suing, but by advising the tenant on how to present his or her own case in small claims. The fusses tend more often than painting to be about carpets. Landlords just love putting in cheap carpets and then replacing them and trying to charge, usually, Amy's right, without depreciating, trying to charge the tenant. Where the tenant is ill-situated to complain is where the tenant has had an animal. Because the landlords they love the word saturated, and they love to say, we took the place back and the carpet and the pad were saturated with cat pee. Whereas the tenant is always saying, oh, Muffy would never pee on the carpet. But the tenant's going to lose that one, honest, unless, perhaps the tenant never really had a cat and the landlord is finally getting around to dealing with the previous tenant's cat. Other than that, these disputes are fact-based. The landlord tends to think that the tenant had a duty to return the property in the same condition as when it was taken. There's a statute that lists the tenant's duties. It is, roughly speaking, to use the premises in a reasonable fashion. And absent landlord proof that the tenant did something unreasonable, the position I take is tenant doesn't owe anything.
Let me throw another scenario at you, and that is you're living in you have somebody who moves in with you on a temporary basis. What kind of problems does that present?
All kinds of problems. If someone is moving in as like a roommate situation, or where they're going to be paying rent and it's a temporary basis, what you may be creating is a month-to-month tenancy, and having to be subject to the Landlord-Tenant Act, which is a dangerous situation. In my office, when we get calls from people who say, well, my roommate won't move out now, I told them they could stay for 2 weeks if they paid me X amount of dollars, and now they won't move, what do I do? And we'll tell them, well, you've created a month-to-month tenancy, you're going to have to serve most likely a 30-day no stated cause termination notice. And the person says, well, I can't do that and I can't afford to hire an attorney, and typically those are the scenarios we see a lot of problems come out of. I'm sure Craig sees it as well.
It can be worse, at least in your scenario. The roommate who moved in agreed to pay rent to the pre-existing occupant and probably created a tenancy. So if you need to sue to get out, you can use the FED procedure, which moves along quickly and will be done in a couple of weeks after the notice runs out. But it's also possible that you've moved in a boyfriend or a girlfriend and that person is not a tenant, and so the quickie eviction procedure is not available. You have to file a kind of a lawsuit called ejectment. The person gets 30 days to file an answer, and endless nuisance.
However, if they're not a tenant, you might be able to get away with
Tough stuff.
tough stuff, such as locking them out, if you can do it without breaching the peace, which sometimes can be difficult. And the police departments typically, if someone can prove that they were living in a place, will not interfere if you're trying to get, say that, well, Joe used to live here, but I've changed the locks. He's not allowed to live here anymore. He's not a tenant. It's not up to the police to decide who's a tenant and who's not. If it's a domestic violence situation, then the one tenant or roommate could get a restraining order against the guest, boyfriend, girlfriend, roommate, what have you, and that could enable the landlord to, if this is a rented unit, and the landlord could change the locks once having proof of a restraining order or some sort of domestic violence situation.
I want to back up to something. You mentioned the FED process. For the benefit of our viewers, just quickly explain what those letters stand for and what that means.
Oh, sure. I think that's short for forcible entry and
Detainer.
unlawful detainer. But nobody uses the unlawful, so it's forcible entry and detainer. Lots of people call it FED for short and think it occurs in federal court, but no, FEDs take place in state court. They are available in two kinds of circumstance. One where a person has used actual force to enter a place, like barged in with guns and taken it over. You can use an FED against them. That almost never happens anymore. And then the other kind of circumstance is where there has been a landlord-tenant relation created, and then the relationship has ended, and the tenant hasn't left. The landlord can use an FED to get rid of the tenant. And from the ending of the tenancy and filing of the lawsuit until the sheriff comes, if things move along with the usual speed, it would be about 20 days, would you say?
Mm-hmm.
Yeah.
Good, thanks for the explanation. Let's talk about this. I'm living in an apartment complex, and I've negotiated a rent, but I discovered that everyone else in that unit is paying less than I am. Is there anything I can do about that?
If you're renting an apartment in an apartment complex and there's different, people are paying different amounts of rent, from the landlord perspective, you need to make sure your rents are based on something that's not discriminatory. Perhaps you have a larger unit, perhaps it's an upper unit, more bathrooms. It could be that the landlord is in the process of raising the rents and has decided that they're going to be raised with each new tenant that comes in, as opposed to raising all the old tenants up and the new tenants. But the primary thing that I look at from the landlord's perspective is there a discriminatory basis? Are you basing the rent because of this person's race, religion, whatnot? And if not, what's the basis? It could be that you have a Section 8, a number of Section 8 tenants, and the Housing Authority has come in and said what they will approve the rent for on these other units, and the new tenant that's coming in might not be participating in the Section 8 program and subject to whatever the market rent is that the landlord believes it's worth.
Absent discrimination against a protected class, like a racial group or a religious or ethnic group, all I can say is too bad for you. You negotiated a bum deal.
Okay. Talk about the unlawful discrimination. If you're feeling that is occurring to you, where do you turn?
You can't.
The Fair Housing Council of Oregon will tackle some of those. It's possible to complain to Housing and Urban Development. They will investigate, and though I'm told that 92% of the cases they investigate, they find no discrimination. You can complain to the Civil Rights Division of the state of Oregon. It's connected with the Unemployment Division, but it mostly, I think, forwards fair housing complaints to HUD for investigation. There are lawyers who have a practice in discrimination. I don't handle those much. Amy and I don't tend to get into it.
I handle some of the Housing and Urban Development complaints from the landlord side. we get maybe 2 or 3 of those complaints a year in my office, and the one thing I would mention about that for landlords is if you do get a complaint filed against you, it's important to seek legal counsel. The first-time offense, if there is discrimination found, is an $11,000 fine. And so it's important to know your rights and make sure that the information that you're passing to Housing Authority or Housing and Urban Development HUD is going through an attorney and making sure that if there has not been discrimination, that someone is advocating on your behalf to the investigator for HUD.
Okay. We have just about a minute left, and so I want to throw out a general question, and that is, where can you go to get more information about landlord-tenant law? Is there, for example, a hotline that you can call or a website? There's
landlord groups out there. I would recommend doing a web search for Oregon landlord groups. Rental Housing Association, Metro Multifamily are 2 separate groups that provide resources for landlords.
The Community Alliance of Tenants often gives good advice to tenants.
That's the Community Alliance for Tenants?
Yes.
Okay.
So, in Portland.
Okay, very good. And we also have, there's information I might add on the bar's website at www.oregonstatebar.org. Well, that's all we have time for today. I thank you, both of you, Amy and Craig. We appreciate your helping us today by providing information about landlord and tenant issues. More information about this subject, as I mentioned, is available online. I'll mention our website again at the Oregon State Bar. It's www.oregonstatebar.org. Our website contains a wide array of information on not only landlord and tenant topics, but other topics as well. And while you're there, you can comment on this program and give us suggestions for future programs. I hope you found this information informative and helpful. On behalf of the Oregon State Bar, I thank you for joining us, and I hope to see you next time on Legal Links.